Yes, Ms. Kelly.
My Lords, I appear for Mr. Kingsley Kanu, the appellant, together with Ms. Eatwell and Ms. Buchanan. And my learned friend Sir James, ED, King's Counsel, appears on behalf of the respondent, together with Mr. Birdling and Mr. Klimowitz. Just before I start, I think it is appropriate to do a little bit of housekeeping to check that you have all the bundles. You should have 2 hearing bundles. One is a core bundle and one is a supplementary bundle. And the supplementary bundle should end at page 527.
527, yes.
Great.
And is there a prize if it does end at 527?
I'm not sure who the prize would be for, but yes, I think there probably is. And then there should be an authority. The authorities bundle should have been supplemented with 2 additional authorities in the last couple of days, El Masri and Bel Haj.
Yes.
And with that, I think the housekeeping ends.
Good.
My Lord, before I begin my submissions, I should say that to begin with, at least, I'll be referring to the judgment below, and that begins at page 97 of the core bundle.
Yes.
My Lords, the issue in this appeal is what obligations and the scope of the obligations which the respondent owes to British citizens who are detained by a foreign government abroad. As my Lords will have seen from the judgment below, the stakes could hardly be higher than they are in this case. 2 years ago, on 19th of June 2021, the appellant's brother, Nnamdi Kanu, was the victim of an extraordinary rendition. Mr. Kanu is a British citizen and he was travelling on a British passport. He is also the leader of the indigenous people of Biafra. He was abducted while he was in Kenya by the Nigerian security forces, held incommunicado in a secret location and ill-treated over several days. Then, on around the 27th of 2021, without any access to due process or a court of law, he was forcibly removed across the border on a secret flight to Nigeria. Once there, he was detained and charged with criminal offences which carry the death penalty. My Lords, as the judge records, and this is paragraphs 4 to 5 of the judgment, these are not just allegations of ill treatment and extraordinary rendition. They are the findings of 2 Nigerian courts, including the Nigerian Court of Appeal. From the 13th of October 2022, that's the Court of Appeal, and the 26th of October 2022. And my Lords, I don't propose to go to those judgments, but I'm going to give you the references, which is what that is what paragraphs 4 and 5 of the judgment below are drawn from. The 13th of October 2022 judgment is at supplementary bundle 298 to 386, and the 26th of October judgment is at supplementary bundle 212 to 251. Mr. Kanu has, in the 2 years since his extraordinary rendition, been in the custody of the Nigerian Department of State Services, which I will call DSS, where he is being held in long-term solitary confinement in conditions which threaten his precarious health. And that, my Lords, is at paragraph 6 of the judgment. He is there and remains there, notwithstanding his success in the Nigerian Court of Appeal in October 22, in overturning the criminal charges against him. That should have led to his release. But the Nigerian government has appealed the dismissal of those criminal charges to the Supreme Court and has obtained a stay in the meantime. But it's important in my submission that the grounds of appeal do not on their face dispute the findings of extraordinary rendition. They argue instead that the court was wrong to find that that extraordinary rendition deprived the criminal court of jurisdiction to hear the criminal charges. And those grounds of appeal are in the supplementary bundle at pages 185 to 192. Just to give a flavour of the sorts of arguments that are being run in the Supreme Court, one of the grounds of appeal, which is at supplementary bundle 188, says that the essence of criminal jurisdiction arising from abduction of a person from a foreign jurisdiction has been, and I'm quoting this, male captus bene detentus, translated as wrongly captured or properly detained. So that is the basis on which the appeal has been mounted, that the criminal court retains jurisdiction, notwithstanding the findings of extraordinary rendition. That appeal still hasn't been heard, neither has Mr. Kanu'S application for bail. It's currently listed for the 14th of September, having been adjourned from a prior hearing date of May 2023. And in the meantime, Mr. Kanu remains in solitary confinement in detention. Now, as the judge also recognises in his judgment at paragraph 3, the extraordinary rendition is not the first time that the Nigerian government have sought to harm Mr. Kanu. 4 years earlier, in September 2017, while on bail for criminal charges, Mr. Kanu was forced to flee Nigeria in fear of his life after the Nigerian military launched a violent raid on his house in which they attempted to kill him. Now, that attempt on his life is also a finding of the Nigerian court from January 2022. That's judgment is at supplementary bundle 261 to 282. Together, all of this means that the Nigerian government planned and executed Mr. Kanu's abduction in June 2021 in circumstances where they must have known that his lawful extradition could never have been achieved because of the risk posed to his life. Now, in all these circumstances, the appellant, Mr. Kanu's brother, has since July 2021 sought urgent assistance from the respondent to obtain Mr. Kanu's release, to protect him from harm while in custody, and to seek accountability for his rendition and ill treatment. My lords, there's no dispute that the appellant has a legitimate expectation that the respondent will consider those requests. That expectation was identified in the Court of Appeal's judgment in Mazi, and I will come later to examine that judgment in detail. Nor is there a dispute that the respondent has considered the requests and taken a range of steps in consequence. And those steps are set out in the judgment below at paragraphs 9, 11, and 22 to 24. Thus, the respondent has intervened on Mr. Kanu's behalf, raising the allegations about his unlawful transfer and his concerns about his ill treatment with the respondent's Nigerian counterparts on a series of occasions. He has sought responses to those allegations, and he has also sought reassurance about Mr. Kanu's conditions of detention. But the respondent has refused to go further, even though he accepts it is open to him to do so. He has not acknowledged publicly that Mr. Kanu is a victim of extraordinary rendition. He has not made representations to this effect to the Nigerian government privately, and he has not called for Mr. Kanu's release. He has also not taken steps to impose sanctions on anyone responsible. Now, my lords, he's explained the approach that he's taken in 3 disclosed ministerial submissions from the 6th of July 2021, the 6th of September 2021, and most recently on the 10th of August 2022. Those ministerial submissions, which I will come back to, are in the supplementary bundle at pages 130 to 144. He's also explained his approach in the evidence of Ms. Sarah Broughton, which is in the supplementary bundle at page 51. And again, I will come back to that. So what is the appellant's case in this appeal and the claim below? Although the appellant wishes that the respondent would take these steps, as the judge recognises, and you can see this from the judgment at paragraphs 17 and also paragraph 26, it is not his claim, and he does not seek by his claim to require the respondent to take those steps. It is the appellant's case instead that in order to take a properly considered decision as to what steps to take, the respondent must first reach a clear internal view as to whether Mr. Kanu has been the victim of an extraordinary rendition. The appellant says that clarity on this prior question is an essential component of a lawful decision-making process and essential to meet his and Mr. Kanu's legitimate expectation. But the respondent has instead, starting on the 30th of June 2021, the day after Mr. Kanu was charged in a Nigerian court, maintained only a provisional view as to the legality of Mr. Kanu's transfer and detention. My lords, can I now ask you to turn up Ms. Broughton's statement in the supplementary bundle at page 68. So the statement begins at page 51. And at page 68 is paragraph 45B, which is part of a list of updates on information that were given to ministers. And you'll see at B that on the 30th of June 2021, the respondent's officials updated Minister Duddridge, the Foreign Secretary, and Minister Adams, setting out the steps that were being taken in Mr. Kanu's case and containing an FCDO's officials' provisional view as to the likelihood that Mr. Kanu's transfer constituted extraordinary rendition and his arrest and detention violating international human rights laws, and as to the involvement of Kenya. And the same point is made at paragraph 47E on page 72. On the 8th of July, a briefing note was given to the respondent's officials, a meeting with the Nigerian foreign minister, containing, you'll see at the end of that, paragraph, subparagraph, an official's provisional view as to the legality of Mr. Kanu's transfer, detention, and the likelihood of trial. My lords, that provisional view, or that view that he has taken, has remained provisional or preliminary ever since. And it remains so to date, notwithstanding the developments in the evidence and the passage of time. And we can see that from the following letters and other documents. So the letter, the respondent's letter of the 14th of April 2022, which is under challenge, one of the decisions under challenge in these proceedings, is at 435 to 437 of the bundle. This is a letter that was written in response to a request on the 23rd of March 2022. You can see this from paragraph from paragraph 1, a request from the appellant to acknowledge that Mr. Kanu had been subject to extraordinary rendition. And you can see at paragraph 3, the FCDO does not consider it would be appropriate to confirm unequivocally that Kenya or Nigeria's conduct was in breach of international law. Instead, the FCDO considers the appropriate response is to continue to raise the circumstances of Mr. Kanu's arrest with both governments. And similarly, in the letter of 9th of June 2022, this is a response to the pre-action protocol letter at 457 to 461. At paragraph 4, previous correspondence has set out the considerable diplomatic efforts which are being made, including at the highest levels, to provide Mr. Kanu with consular assistance and to make representations on his behalf. In deciding to take these steps, the Secretary of State has necessarily formed a provisional view on the information available to her as to whether the allegations are credible and as to whether they either do or may constitute a violation of international law. The Secretary of State is not prepared to share this view, and does not consider it appropriate to do so. And then again, at paragraph 17, the Secretary of State has considered what steps would most assist Mr. Kanu with regard to her provisional view. This is at page 459, as to the legality and gravity of Mr. Kanu's treatment, as well as the representations submitted by your client alongside advice from the FCDO. And in Ms. Broughton's witness statement, turning back to that in the supplementary bundle at 67, I'm sorry, the supplementary bundle at 65, this statement you'll see at the end, which is at page 76, is dated the 4th of October 2022. You'll see, so at paragraph 39, when considering what further steps are necessary, the FCDO will often, as it has done in this case, reach a preliminary view as to the credibility of the allegations based on the material available. In conducting this assessment, the weight that is accorded to various pieces of evidence varies depending on the circumstances of the individual case. My Lord, rather than me read this out, could I ask you, because these paragraphs are going to be important, to read paragraphs 39 to 42?
Yes.
Or 43, in fact.
Yes.
So, my Lords, you'll see that on the basis of that preliminary view, the decision has been taken as to whether to make a public statement, and that a number of other factors have also been taken into account. And then at 42, Ms. Broughton has explained that forming a concluded view in the face of evolving evidence would not be appropriate, and that reaching or publishing a concluded view would not change our objectives or how we've approached the case. and at 43, she cannot foresee what new evidence will come to light. And then if I could ask you at 44C, which is at 60, to look at 44C, you'll see that the submission that was made, the ministerial submission that was made on the 10th of August, considered the option of calling for Mr. Kanu'S release. In the middle of that paragraph, the government's policy was that calls for release should be a last resort in exceptional circumstances. And at the end of that paragraph, the submission also contained provisional and legally privileged advice, so we can't see it, as to Mr. Kanu'S allegations of arbitrary detention. So that was Ms. Broughton's position on the 4th of October 2022. My Lords, it hasn't changed in the light of the judgments of the Nigerian Court of Appeal and High Court. And you can see that from the recent correspondence, which is an exchange at supplementary bundle 473 and 475. And at 473, you'll see a letter from the appellant's solicitors, Bindmans, asking towards the end of that letter, referring to a paragraph of Mr. Justice Swift's judgment, which stated, paragraph 29, no doubt the Secretary of State's approach will now also be informed by the conclusions set out in the judgments of the Court of Appeal in Nigeria, given on 13th of October, post-dating the evidence filed in these proceedings. I've seen reference in correspondence to a note for bail sent on the 24th of October 22, presumably sent in the light of those conclusions. And the letter at the bottom of the page says, at last, please confirm that it remains the Secretary of State's position that the internal view on what has happened to Mr. Kanu even now remains provisional because of the evolving evidence and the constant inflow of new information. It's referring back to Ms. Broughton's statement, which you've seen. And the reply comes at page 475,
Yes.
paragraph 3. The Nigerian government is, our client is aware of the decision. The Nigerian government is currently appealing the judgment of the appeal court to the Supreme Court. As such, the nature of this case continues to evolve, and our client will assure he remains apprised of any new information. That is the response to that question, and it must therefore continue to be the case that a provisional view has been taken. And indeed, that is the position recorded in the Secretary of State's skeleton argument a couple of weeks later, on the 30th of May 2023. You can see this in the core bundle.
Well, just before leaving, can I just invite you to cast an eye down the rest of that letter so you can see what action has been taken in the light of those developments?
Yes.
Thank you.
You don't need the details, just to get the sense. Yes.
My Lords, just since you have been asked to look at it, at 4A, you'll see that some further note for bails were sent to the Nigerian government, including one on the 19th of December 2022 and a further one on the 2nd of May 2023. It's at 475. And there was, for the first time, as we understand it, a response to one of those note for bails from the government of Nigeria. We haven't had any information from the respondent about what that response contained, and there's been no disclosure of either the note for bail or the requests. My Lord, so the skeleton argument is at core bundle 57. Begins at at 56, but at paragraph 2, you'll see how the respondent characterises the appellant's appeal as being Secretary of State is obliged in public law to intervene in a particular way by reaching an effective final view on the allegations. Secretary of State has declined to take that course. He has confirmed that he has considered those allegations and has formed a provisional view as to their credibility and on whether they may constitute a violation of international law, but has declined to share that view. So, my lords, the position remains that the Secretary of State's stance on whether Mr. Kanu has been the victim of an extraordinary rendition is provisional. And that means that all the decisions on what steps to take have been taken on this uncertain, provisional, or preliminary basis. And it is the appellant's case in this appeal that starting point is unlawful for 3 reasons. It's a breach of his legitimate expectation, that's ground 1, based on Abbasi, and the requirement that's set out there in a number of paragraphs 92, 99, and 99, and I'll come back to them, to at least start from a formulated view as to whether there has been a breach of rights and as to the gravity of the resulting denial of rights. That's ground 1. This is all in the appellant's skeleton argument, which starts at page 71 of the core bundle. Ground 2 is it's irrational due to the overwhelming evidence of extraordinary rendition and the fact that there is no prospect of that evidential position changing. And ground 3 is that the respondent has acted unfairly in not either informing the appellant of what the provisional view is or of the factors which would cause it to shift. My lords, the judge rejected all these arguments. He rejected the argument that the court in Abbasi had said there was a need to start from a concluded view, saying there was no such first step. That's paragraph 28 of the judgment, which is core bundle 113. He said, as my lords will have seen, that in practice what is required is that the respondent is sufficiently informed, which is akin to the standard in the House of Lords judgment in Thameside, requiring the respondent to take reasonable steps to acquaint himself with relevant information. That's judgment, paragraph 28. He also said that the respondent's refusal of the request to reach a concluded view, quote, does no more than reflect the Secretary of State's opinion, this is judgment, paragraph 29, on how best to conduct his affairs with the Nigerian authorities to give the greatest chance of providing practical assistance to Mr. Kanu, and that it's part of the conduct of international relations. He also rejected the argument that it was irrational for the respondent to maintain his provisional view, again holding that the refusal to state the view reflects the respondent's opinion on what steps should be taken best to assist him, and is part and parcel of the respondent's assessment of how to conduct foreign relations. And he says at paragraph 32 of the judgment that the distinction which the appellant has drawn between reaching a view privately and stating it publicly is artificial. That's in the judgment at paragraph 32. And finally, he has found that there is no requirement for the respondent to act fairly, stating at judgment paragraph 35 that the respondent is not exercising a power that attracts an obligation of procedural fairness. And my lords, the appellant appeals with permission against each of these conclusions. In short, it's my submission that they're inconsistent with both the law and the evidence. But before I come to those grounds of appeal, which I will take in turn, I want to address why reaching a clear or concluded view matters in this case. Why does it matter to the appellant? And the question arises because if, as the appellant accepts, the respondent may be entitled to keep any concluded or clear view he reaches private, he may be entitled to do that in the exercise of his discretion. And if, as the appellant accepts, subject to any lawfulness, he may decide, subject to acting lawfully, he may decide not to take any different steps. Why does it matter whether this private view is provisional or not? And my lords, the simple answer to that question is that reaching a clear view as to whether Mr. Kanu was the victim of an extraordinary rendition could make a difference to the steps taken. It is thus a logical first step in the decision-making process.
Write this down because I sense that it's important. Why does reaching a clear concluded view matter? Answer,
Because reaching a clear view as to whether Mr. Kanu was a victim of extraordinary rendition could make a difference to the steps taken. It is thus a logical first step. On the other hand, the respondent's position, which is maintaining a provisional view because he has already decided not to take the additional steps that are sought by the appellant, is back to front reasoning. It approaches the decision-making process the wrong way round. It says, what would I do? And therefore, is it necessary for me to reach a concluded view privately, as opposed to, has he been the victim of an extraordinary rendition? Yes or no? Therefore, what should I do? That is the obvious, in my submission, logical and correct way to approach the decision-making process. So what difference could it make if the Secretary of State reached a concluded view? It provides, in short, the justification for him to take a series of escalated steps to assist a British citizen detained abroad. My lord, the approach that the Secretary of State takes, the respondent takes, when a British citizen is detained abroad is set out in the Prisoner Policy Guidance, which is in the supplementary bundle. The paragraph I want to, the part I want to look at is at page 79. See, it starts at 78. And you can see, first of all, a distinction that is drawn between intervention and interference. And what is said is that the UK government can intervene on behalf of a British national under certain circumstances. This is usually where we have concerns for the health, welfare, or human rights of British nationals, or have concerns that they are being unlawfully or unjustifiably discriminated against. And this is what we can consider intervention. And a list of possible grounds for intervention is set out below. Health and welfare concerns, torture or mistreatment, death penalty, and so on and so forth. We cannot consider interference. Intervention must be appropriate, this is at the bottom of the page, and justified. Under international law, we cannot interfere in the internal affairs of another state, including their judicial proceedings. The UK's internal affairs are similarly protected from foreign interference. And then there is a list of matters that are likely to be considered interference. expressing an opinion. This is over the page at 80, expressing an opinion on the guilt or innocence of the accused, seeking to influence the court's judgment on a case. And other examples are given. So, my lords, there is always an imperative to avoid interference, but there is a need, nonetheless, to intervene where there are concerns. But and you can see how this works in Miss Broughton's witness statement at paragraph 3, which is just before this in the bundle at page 54. Sorry, page 52. This is the raising of allegations with the respondent, with the Nigerian authorities. And you can also see in the way that she describes the policy at paragraphs 8 onwards at 53. This distinction between intervention and interference. And what is happening at paragraph 14 when you send a note for bowels. We may signal, this is at page 55, we may signal to local authorities we have an interest in the case by sending a note for bail. We may ask questions, this is at paragraph 14. Often, this is from the PPG, the Prison Policy Guidance, asking questions can act as a prompt for concerns to be addressed, or the answers may act as the basis for further intervention. And she goes on to describe the purpose of how lobbying may assist. And what is clear from all of these steps is that forming a concluded view as to whether there's been a violation of international law is not essential to intervention of that type. Expression of concerns, raising allegations, or seeking assurances that a British national will receive a fair trial. These types of steps can be taken on the basis of preliminary views and on the basis of the allegations that are made. But, my lords, those steps have already been taken over the last 2 years in Mr. Kanu'S case. And you can see that, and Miss Broughton has explained that the allegations, this is at paragraph 2, have been taken most seriously and repeatedly raised in formal communications. The latest letter that my learned friend asked you to read further into, again, sets out all those types of communications. But what is important is that justified intervention is not limited to those raising those kind of concerns or allegations or asking for further information. It can include more robust steps. And at this point, I would like to ask you to look at the ministerial submission of the 10th of August 2022, which is at page 141 of the bundle. Supplementary bundle, I should say. And this ministerial submission, which starts at 140, was in response to a request from those instructing me that the respondent take further steps in relation to the fact that Mr. Kanu had been the victim of extraordinary rendition, and ask for his, both acknowledging that fact and asking for his release. And you can see, if I could ask you then to read paragraphs 8 to 10 of this ministerial submission.
Yes, how far did you want us to get?
Just to the end of 10.
Right.
In the first instance, I'm going to ask you to look over the page. But so you'll see at paragraph 9 that ministers retain the discretion to depart from policy and call for release in exceptional circumstances, provided there's a rational basis for doing so. The principal exceptional circumstance where ministers have previously called for release, so it has been done, is where the FCDO has credible evidence to suggest the detainee is arbitrarily detained, although to date that has only been done in very limited circumstances. So you can see there that it is possible to call for release where there is credible evidence to suggest the detainee is arbitrarily detained. And realistically, given how exceptional that is, it's not going to happen unless there is a clear and concluded view has been taken that the individual has been the victim of an extraordinary rendition. That option remains available there. And you can see over the page why it is not recommended. What is recommended is continuing lobbying, because calling for release is exceptional. You see this at paragraph 11. Human rights violations cannot be, it needs to be done where human rights violations cannot be remedied by other means. Where we judge that call for release is a credible and effective step, we assess there are still further steps can be taken before consideration of this exceptional measure. Lobbying and escalation, you'll see, and at the end of that paragraph, monitoring ongoing legal proceedings in Kenya and Nigeria where the allegations are being considered. And you can then see at paragraph 13, the option is not recommended. We do not, to call for release, we do not assess lobbying has been exhausted, nor that all legal remedies have been exhausted, nor is it clear that a call for release would be credible or effective. The civil proceedings in Kenya and Nigeria remain ongoing. And then it says here, there will therefore be opportunities for the courts in Kenya and Nigeria to consider the allegations and potentially provide remedy to the alleged rights violations. British High Commission Abuja and Nairobi can also further escalate lobbying on the allegations to try and obtain a response from both governments. And then there is a concern that calling for release at this stage, before it's a measure of last resort, could set an unmanageable precedent. And the submission then goes on to say that it would be effective at paragraphs 14 onwards. So, my lords, calling for release in exceptional circumstances is available, and you can see from Ms. Broughton's witness statement, I won't ask you to turn it up again, but it's
Sorry to interrupt.
Yes.
Who or what is post?
I think that's the commission in the British High Commission, as I understand it.
Thank you.
And so without turning it up again, Ms. Broughton's witness statement at page 63 of the supplementary bundle at 36A accordingly says it's extremely rare to definitively state that treatment is illegal in international law. This is publicly. But it's rare, but it is possible. And she repeats, referring back to this same policy in the ministerial submission at paragraph 36E, this is page 64 of the supplementary bundle, is that government policy is that no representations for release of British nationals detained abroad are made other than in exceptional circumstances and usually as a matter of last resort. So, my lords, the fact that this is not merely a theoretical option, however rare, is made clear from a series of examples that are given in Ms. Shirin Marker's second statement in the supplementary bundle at pages 145 to 151, at paragraphs 8 to 27. And you'll see that in those examples that she gives, the respondent has, on several occasions, made public statements concerning the legality of an individual's detention by a foreign government and has also called for their release. Those examples date from a series over the decades from 1984 onwards, including in relation to the United States, rendition flights at paragraph 12, paragraph 16, the treatment of Uyghur Muslims in Xinjiang, and at paragraphs 22, the requests by then Foreign Secretary Dominic Raab, February 2021, for the immediate and permanent release of all arbitrarily detained dual British nationals in Iran, and the requests for release in Iran by then Foreign Secretary Liz Truss on the 1st of October 2021, British national Murad Tabaz, unjustly detained in Iran, paragraph 24, Nazanin Zaghari Ratcliffe, appalling decision to proceed with these baseless charges, appalling continuation of the cruel ordeal that she is going through. And there are other examples given there as well, including paragraph 26 by the former Prime Minister Boris Johnson, acknowledging that the Indian government was arbitrarily detaining Jagtar Singh Chahal. So it can be done. But obviously and necessarily, when it is done, a conclusion is going to have to be reached that someone has been arbitrarily detained. But that is not the only difference that a concluded view could make. It could also make a difference to the decision as to whether to impose sanctions on an individual, to designate a person for sanctions. And that is dealt with in Ms. Shirin-Marker's second statement at paragraphs 28 onwards, at page 151. And she refers there to the Global Human Rights Sanctions Regulations 2020, which is in the Authorities Bundle, tab 20, at page 645. If I could just briefly turn that up. And you'll see it, Regulation 4, page 646. The purposes of the regulations contained in this instrument are to deter and provide accountability for activities falling within paragraph 2. An activity falls within this paragraph if it's an activity which, if carried out by or on behalf of the state within that territory, within the territory of that state, would amount to a serious violation by that state of an individual's right to life, right not to be subjected to torture or cruel, inhuman or degrading treatment or punishment, or right to be free from slavery, not to be held in servitude, or required to perform forced or compulsory labour. And just to be clear, extraordinary rendition includes within its definition arbitrary detention and transfer in the absence of lawful process for the purposes of ill treatment or interrogation under torture. So that is part of the definition, and I can give you that's what the authorities Vel Masri and Bel Haj make plain. And then at Regulation 6, the criteria for designating a person. The Secretary of State may not designate a person under Regulation 5 unless the Secretary of State has reasonable grounds to suspect that person is an involved person. And an involved person, without going through the full definition, is involved in one of these activities. Now, reasonable grounds to suspect is a a relatively low test, but that doesn't mean that the Secretary of State is realistically going to impose sanctions or designate a person where he has only reached a provisional view that the activity has taken place. And if that wasn't obvious, it is made obvious by the guidance at tab 21. This is the designation guidance, tab 21 of the authorities bundle. And you'll see that the factors that the government will have regard to, following factors are likely to be relevant, but this list is not exhaustive. This is at page 674. And you'll see paragraph 3, the seriousness of the conduct. Her Majesty's government is likely to consider the scale, impact and nature, both of the human rights violation or abuse and a person's involvement in that human rights violation or abuse, including whether the conduct has a systematic nature or is part of a pattern of behaviour. So again, realistically, it is inconceivable that the Secretary of State would designate somebody for sanctions in circumstances where she hasn't even formed a concluded view herself as to whether the underlying activity that there is said to be a reasonable suspicion that they're involved in constitutes a breach of international law, such as an extraordinary rendition. So that's the position in relation to sanctions, and you can see the respondent's own approach to that in the ministerial submission of 6th of September 2021, which is in the supplementary bundle at 139. This is her approach to it in this case. And I should say that make clear that the first 2 ministerial submissions include, and this is the 2nd of July 2021 and September 2021, were made before the respondent had gained access to Mr. Kanu in detention. So they were made before any clear information had emerged. So this is 139, the start of the submission is at 134, and at the back there is an annex of options, recommendations as to what course to take, and then there is an annex of alternative options which were not recommended. And you can see at 139 the sanctions option. If I could just ask you to read that rather than reading it out. So the respondent was looking for evidence to substantiate the allegations before considering imposing, or before deciding to impose sanctions, not clear whether the case meets the evidential thresholds. So that's sanctions. Diplomatic protection is another option that is available. And that's described in the prisoner policy guidance at page 104 of the bundle.
I don't know much about this, Ms. Kilroy, but can you do that where the individual is a dual citizen?
It is, yes, you can. I mean, there may be a dispute with the member state, the other state, as to whether they will accept that dual protection is being exercised, but it is possible on the respondent's approach to it. And that was done, in fact, in relation to Nazanin Zawi Ratcliffe, who is a dual national. And you can see, so diplomatic protection is dealt with in the prisoner policy guidance at page 104. And you'll see at 105. Sorry, at 104, you'll see that diplomatic protection at the bottom of that page. Diplomatic protection is the process under international law by which one state pursues a claim against another state on the basis that it has committed an internationally wrongful act against its nationals. So the commission of an internationally wrongful act is the necessary prerequisite for considering whether to impose it. And then you'll see again at 105, it's extremely rare. This is just under the heading diplomatic protection, a right of the state, the third paragraph. In practice, diplomatic protection is very rare and considered on a case-by-case basis, exercised at the discretion of the Foreign Secretary. This means there's no duty to exercise it, even if the conditions to exercise it are present. The conditions that must be present to consider diplomatic protection include the commission of an internationally wrongful act, the exhaustion of local remedies, and proof of nationality. And then there is guidance on diplomatic protection. You can see that they may take up a claim for a dual national in a third country. HMG will not normally take up the claim of a dual national in their country of other nationality. However, exceptionally, HMG may take up the claim of a dual national against their country or other nationality where it has treated them as a British national in the circumstances that gave rise to the injury. So,
Is that this case?
well, my lords, I can see that that is something that would have to be considered as to whether he had been treated as a British national in this particular case. But the point as far as this submission is concerned is that these are all criteria that need to be considered, and one of the criteria is whether there's been an internationally wrongful act against a British national.
Yeah.
And you can see that again in that submission, in the ministerial submission of September 2021 at 139, that diplomatic protection was one of the options considered. We could consider extending diplomatic protection to Kanu, although it is unlikely that he would meet the criteria for consideration as domestic avenues have not yet been exhausted. So that's the reason that's given. It's not the reason that he's not being treated as a British citizen in the Act. But I should say, I said at the start that Mr. Kanu was travelling on a British passport when he was transferred and rendered. So diplomatic protection is one of the options. And
Only where local remedies
yes,
have not been exhausted.
well, that's right. But that also means when it looks as if those remedies are not effective. And it's part and parcel of the assessment that has to be made, whether there's been an internationally wrongful act, except there are other criteria. But diplomatic protection is one of the options available. It's simple. I absolutely accept that it is the last option in a series of options, but it is an option, and it is a further reason when someone has been detained in solitary confinement for 2 years to reach a conclusion on whether they were the victim of extraordinary rendition or not. So, my lord, calling for release, making a statement about whether someone has been the victim of an internationally wrongful a breach of international law, in this case extraordinary rendition, sanctions, and finally diplomatic protection are all options that are available as escalation when the expressions of concern, the note verbal, the lobbying has not worked. And in my respectful submission, reaching a concluded view, clear and conclusive view, as opposed to a non-provisional view, is a critical component of properly considering those options and could make a difference. So can I turn now to the grounds of appeal? And the first ground,
Ms. Kilroy, just
Yes.
before you do, can I just ask you this, just talking around this question of the concluded view, taking it in stages, I assume you accept that initially at least, the Secretary of State was entitled to form a provisional view.
yes,
So when was it, you say, that he was obliged to come to a concluded view?
when the evidence warrants it, my
No,
lord.
no, when on your case,
Oh, I see.
was he obliged to come to a conclusion? And then obviously the follow-up question is why? Because this is actually all temporal. So I just want to try and understand what the case is as to when and why the position would have shifted.
Well, I mean, the first and most obvious answer to that question is there's not a precise date. I, of course, accept on the appellant's behalf that in the initial days when an individual has been detained, a process of investigation has to be undertaken to establish the circumstances in which they've been detained and the lawfulness of their treatment. And in order, I also accept, indeed, I assert that in that period of investigation, the respondent is quite right not to simply take no action, but to express concerns based on preliminary views that he is able to reach on the treatment of that individual. But as the evidential picture develops, then the Secretary of State is, in my respectful submission, obliged to, as soon as it is possible to do so, reach a clearer, non-provisional view. And in this case, what happened was that the Secretary of State was, for many months, requesting explanations by way of note verbal. You can see that from Ms. Sprouton's statement as to what had happened to Mr. Kanu, the circumstances of his arrest and transfer. Those requests started going out as early as the end of December 2021 and was getting no response.
How do we know that there was no response? The interactions were mainly, as I understand it, face to face, and then fairly recently, a net verbal from Nigeria to UK. We're not told either what the response was in the note verbal, nor what various representatives of Nigeria said.
Well,
Meetings, are we?
Well, my lord, we are told that there wasn't a response to the questions or allegations that were made about the transfer, and I'll have to track down the paragraphs of Ms. Sprouton's statement. But there is no dispute, as I understand it, between the parties that until that there has never been, and it's not clear to me whether this most recent note verbal is a satisfactory answer to the questions that have been raised. But at least until that point, there has never been a satisfactory answer from the respondent, from the Nigerian government, from either the Kenyan government or from either the Nigerian or the Kenyan government to the respondent's questions in relation to the circumstances of the transfer. And I will make sure you have the paragraph numbers in Ms. Broughton's statement to that effect, or in the evidence. But that is our understanding. There has not been an answer. There's not been an explanation given. And one of the important things about the evidence that was below, and I haven't taken you through it, but it's recorded in the judgment, is that the Nigerian government, we do have an affidavit that was submitted by the Nigerian government in the Nigerian proceedings, which effectively admits the unlawful transfer, because it positively asserts that there was no extradition. There was no need to comply with any extradition treaty, according to the Nigerian government, because Mr. Kanu was said to have jumped bail. And it was the Nigerian government's position in that affidavit that they were therefore entitled to go onto Kenyan soil and apprehend him and bring him back. Obviously, that is not a position that is consistent with any law. The Kenyan government had also put in their evidence, and again, I can give you these references. The Kenyan government had also put in their evidence to proceedings in Kenya that Mr. Kanu had entered the country, was recorded as having entered the country through immigration, but there was no record of him having left. And there was no extradition. They were not party to any extradition. That's their case. That's their defence.
And what is the appeal to the Supreme Court about?
Well, my lord, perhaps it's not very long. The appeal to the Supreme Court is at 168 to 192. And it is focused on the jurisdiction issue. Sorry, I've given you the wrong page number. It's actually, that's the start of Mr. Ejimako's statement. It's page 185 of the bundle. And it ends at 191. And what you'll see is that what is said, just to give an example, if you see particulars of error on page 186, the court below relied heavily on the alleged mode of entry, brackets, abduction and extraordinary rendition, end brackets, of the respondent from Kenya to Nigeria as a basis to hold that the trial court had lost its jurisdiction to entertain the charge before it, even when it is not in contest, and there is sufficient evidence in the proof of evidence contained in the records of appeal before the court to show that the respondent was standing trial and flouted the orders of the trial court and jumped bail. And then at 3, Roman 3, the court below erred when it held that the executive arm of the government must not be allowed to benefit from his wrong, brackets, abduction and extraordinary rendition of the respondent, end brackets, when in fact and by its judgment, the respondent was allowed, that's Mr. Kanu, to benefit from the illegality of his disobeying the orders of the court when he jumped bail. And I should pause there to say that that's why I've pointed out the judgment of the Nigerian court in January 2022. He left the country, he was on bail when the Nigerian military raided his home and attempted to kill him, according to the Nigerian court. So that's why he fled. Disobeying the orders of the court when he jumped bail and was rewarded with a discharge from the charges pending against him at the trial court, thereby occasioning a miscarriage of justice against the state and the victims of the crimes. And the same point is made in a number of different ways. And you can see a similar point made at ground 3.
I appreciate your cases. All this is nonsense, but at the moment I'm looking at what the grounds of appeal are.
Yes.
It doesn't seem to me, looking at these grounds, that they involve an admission of illegal behaviour on the part of the government.
Well, my lord, they don't challenge the conclusion of the Court of Appeal that transferring the Mr. Kanu from Kenya to Nigeria in the absence of an extradition, an order for extradition, was amounted to an extraordinary rendition. And the Court of Appeal in its judgment went through both domestic law, in a local human rights law that was Africa-wide, and international law. It looked at Bentley, for example, looking at the House of Lords decision in that case.
No, I understand that, but
So these are not challenged.
Ground 3 at the bottom
Yes.
of page 187 says the court below occasioned a miscarriage of justice when it held that the rendition of the respondent is unlawful.
Yes, well, my lord, that case is about a domestic principle. Patrick Giovins and others is about a domestic transfer across states in Nigeria, as I understand it. So it's the international law finding. These are all domestic law arguments about the consequences for criminal charges of this international law wrong. That's what this appeal is about. And so that is why, and what's more, if your lordships look at the judgment of the Nigerian Court of Appeal, and it may be worth having a brief peruse of some of its key conclusions. The point is that in those proceedings, there was no evidence, proper evidence, dealing with the extradition in those particular proceedings. The affidavit I referred to is in another proceedings. And so what the court found is that there was no proper denial of the allegation of extraordinary rendition. Now, this is going on appeal to the Supreme Court. It's not, there isn't going to be any further evidence in the Supreme Court in relation to the extraordinary rendition. So, my lords, the basic point is that the evidential picture is not going to change. The Nigerian courts of various hues, as recorded in the judgment below, have all found that this amounts to an extraordinary rendition. There is, I accept, that's why the appeal, there has been a stay on the appeal. There is, I accept, a possibility that the Nigerian court may find, notwithstanding, the Supreme Court may find, notwithstanding this serious breach of international law, that Mr. Kanu can go on to be tried for charges that carry the death penalty, which is what he's facing. But that would not be a reason for the Secretary of State not to reach a concluded view on whether there's been an extraordinary rendition. Indeed, that would be a reason for reaching such a view, because if from an international law perspective, as the Nigerian court itself found, an extraordinary rendition invalidates such actions and would render any implementation, even if the respondent accepted it more widely, of the death penalty particularly egregiously unlawful. So, my lords, we still come back in my respectful submission to the same point, which is that the evidential picture now, 2 years after Mr. Kanu was detained, first detained, after multiple requests for further information from the Nigerian government, after the United Nations Working Group on Arbitrary Detention has itself expressed a view, that's recorded in the judgment as well, has itself expressed a view that Mr. Kanu has been the victim of extraordinary rendition. That's in the bundle, supplementary bundle at pages 507 to 523. That's the UN Working Group on Arbitrary Detention. And when the Nigerian courts have reached that view on the evidence before them, and there is no further possibility of any further material emerging on that question of whether he's been extraordinarily rendered, because the position is so clear, there is no reason for the respondent's view to remain provisional. I mean, in short, in colloquial language, what is the respondent waiting for? What does the respondent expect to emerge as a result of future proceedings, which is going to change the position? And indeed, that's one of the questions that is raised by ground 3. There is no proper explanation of what it is that the respondent is waiting for. There isn't going to be an evolution of any evidence on the critical question of whether there was an extraordinary rendition or not. Yes, there is going to be an evolution as to whether the Court of Appeal's conclusion on quashing the criminal charges will be upheld, but not on anything else, in my respectful submission. And in any event, it's not necessary, even if there had been a challenge to the findings of extraordinary rendition as a matter of international law, it would not be necessary to wait unless there was a good reason to suspect that something new was going to emerge. The government could have lodged an entirely spurious appeal against the findings. And in those circumstances, it would still be necessary, in my submission, not in that position, but it would still be necessary for the Secretary of State to reach a conclusion himself on the material. Why? Because a British citizen has been the victim of a serious breach of international law, one of the most serious breaches that there can be, which is to be abducted in a foreign country and transferred violently over a border and then charged with a death penalty in circumstances where that foreign government could have sought extradition by lawful means. I mean, what more serious breach could there be of a British citizen's rights? He's been kidnapped. And we are now at the position 2 years on where it is necessary, in my respectful submission, and obligatory, given the state of the evidence, for the Secretary of State to come off the fence and reach a conclusion about what has happened. And my lords, could I now turn to Abbasi?
Yes.
On ground 1, because
Just-
in my submission it's clear.
Just
Yes.
before you do, my lord asked the question, well, when?
When?
And you said, as the evidential picture develops, the Secretary of State is obliged as soon as possible to reach a non-provisional view. Presumably, on the basis that the decisions you challenge are dated April and June of 2022, that's the date on which he should have reached his non-provisional view.
Well, yes. So
But she at that time, I suppose. I can't remember.
yes. Well, there has been a change.
Yeah.
Well, it was the appellant's position, because what the appellant did prior to the decision of the 14th of April is to send the respondent a range of evidence about what had happened, including evidence that he had gathered about flight paths and so on. And all of this is explained in the witness statement of Ms. Marker, the first witness statement put in with the proceedings, showing that the evidence demonstrated there had been an extraordinary rendition. In other words, a rendition without any lawful process, a secret flight, and so on. So that was the position at which the appellant brought his initial challenge. But obviously, this is an ongoing challenge. So whether or not this court or the court below felt that that point had been reached in April 2023 is
22.
sorry, in April 2022, the position has continued to change, and the United Nations Working Group report, the United Nations Working Group on Arbitrary Detentions report emerged in August in the late July 2022, and then these judgments in October 2022. And it is the appellant's position that whether or not the evidence permitted it in April, which it and that is the appellant's pleaded claim, it certainly does now. And what we see is that, notwithstanding those changes that and the clarity of the position that we have reached now, the Secretary of State continues to maintain a provisional view. And the reasoning that is given appears to be that because he has decided not to take action, it's not necessary to reach a concluded view. And in my respectful submission, that cannot possibly be right. It is the first logical step, and this is where I began, was the individual a victim of extraordinary rendition? And if so, what steps to take? And my lord, I think it is important now to look at Abbasi to see where that argument comes from.
Can I just, while I
It's
think
at
of
tab
it,
8.
say, I understand the difference between a concluded view and a provisional view. You've at some points referred to a concluded view, some to a clear view,
Yes,
sometimes to a formulated view.
yes.
Is there any difference between that? I would have said clearly a provisional view is different from a final.
Yes.
Final straight concluded. But is formulated view something different?
The formulated views we'll see is language that was used in Abbasi.
What does it mean? The formulated view might be it's too early to say.
Well, the formulated view on whether someone has been the victim of it, as we will see, that's the context in which the language is used in Abbasi. It's a formulated view as to whether someone has been subjected to a breach of international law, and if so, its gravity. That's the way it's put. But I mean, the simple answer to your question is there's not intended to be a difference. Really, what all of those terms are supposed to do is provide an opposition. It's really not a provisional view. It's a way of saying not a provisional view, not preliminary.
So you say formulated can't be a provisional view.
I say in the context in which we look at Abbasi, formulated can't be a provisional view.
Right, let's look at Abbasi.
So Abbasi is at tab 8 in the authorities bundle. It starts at authorities 252. And my lords, without going back to it, the case of GCHQ is in the bundle at tab 2, and as the court explains in Abbasi, until that case it was thought that the exercise of prerogative powers like the one being exercised in this case was not amenable to judicial review. But the House of Lords in that case, and this is in the various speeches, but encapsulated in Lord Scarman's speech at 407F, which is in page 99 of the authorities bundle, is that the controlling factor in determining whether the exercise of prerogative power is subject to judicial review is not its source, but its subject matter. And since that point, the position has been that if the subject matter or factual application of the power is suitable for review, prerogative powers are reviewable on the common law grounds of illegality, irrationality, and procedural impropriety. And that's Lord Diplock's speech at 410C to F. Now, because Lord Roskell in GCHQ had identified a series of prerogative powers which he thought might not be susceptible to judicial review, and listing the making of treaties, the defence of the realm, the prerogative of mercy, and the grant of honours as some of the examples. The courts have naturally seen a series of challenges in which all of these suggestions of potential immunity have been explored and refined. And one of those judgments is, of course, Abassi. And we can see the court applying the GCHQ approach, and also another important case of Everett at paragraphs 81 onwards. And it's at 280 of the bundle. And could I just ask you first, before we delve further into it, to look at paragraph 80 and what the court said there in the sidelined passage is that there are three considerations which have led us to reject the proposition that there is no scope for judicial review of a refusal to render diplomatic assistance to a British subject who is suffering violation of a fundamental human right as the result of the conduct of the authorities of a foreign state. So the first, the source of all of this jurisdiction and expectation is the suffering of a violation of a fundamental human right. And the court gives the first consideration, which is the development in the law in GCHQ and the doctrine of legitimate expectation. And then at 85, the court says those, referring to the extracts which I just alluded to myself in GCHQ, these extracts indicate the issue of justiciability depends not on general principle, but on subject matter and suitability in the particular case. That is illustrated by the subsequent case of Everett, which concerned a decision not to issue a passport. Lord Justice Taylor summarised the effect of the GCHQ case as making clear the powers of the court cannot be ousted merely by invoking the word prerogative. So you can't just raise the flag and then the courts will look away. And then the court showed in that paragraph what I say is now a consistent theme across the case law. You'll see in the quote from 85 that there is a careful examination of whether the issue in fact engages the subject matter that is said to be non-justiciable or not. And in that case, the court found that the grant or refusal of a passport raises issues which are just as justiciable as, for example, the issues arising in immigration cases. And then the second consideration which led them to conclude that the matter was reviewable is at paragraph 87, and that is the policy capable of giving rise to a legitimate expectation. And the court goes through various passages in the policy and statements in Parliament 91, and then summarises the and at 91 you'll see in the quote from the parliamentary answer from Baroness Scotland at the end in the italicised words, the UK government would also consider making direct representations to third governments on behalf of British citizens where we believe they were in breach of their international obligations. Paragraph 92, taken together, these statements indicate a clear acceptance by the government of a role in relation to protecting the rights of British citizens abroad, where there is evidence of miscarriage or denial of justice.
Well,
Yes.
sorry. Fairness Scotland's statement does say, in cases where a British citizen may have suffered a miscarriage of justice, we believe that the most appropriate course of action is for the defendant's lawyers to take action through the local courts.
Yes,
Of course, Mr. Abbasi couldn't do because he was in the black hole.
yes. Well, that's right, my lord, but I don't think it's being suggested that that the expectation does not arise even when that is happening. And one of the reasons for that is you'll see from the ministerial submission, the 1st July 2021 ministerial submission, is that the expectation of the respondent was in fact that the local courts in Nigeria would not provide a fair outcome in Mr. Kanu'S case. My lords, I'll give you the reference for that because it's clearly important. But that is one of the reasons why, in this case, submissions and concerns were raised straight away. You'll see at page 1, it's 130. Paragraph 6, given the political context and pressure from the executive, we do not expect the trial schedule, this is supplementary bundle, scheduled for 26th to 27th July to be free and fair. Now, of course, that only highlights the importance of the judgments which were in fact reached. Despite all that pressure and political context, they nonetheless found, these particular courts nonetheless found that there'd been an extraordinary rendition. But it's not the general expectation, as this submission makes clear, that the proceedings as a whole, and that may include what happens in the Supreme Court, will be free and fair given the political context and the pressure. So, of course, by way of example, my lords,
But you
yes,
perhaps you're having your cake and eating it. I mean, speaking for myself, it seems it's a powerful fact in your client's favour that a succession of courts,
yes,
including the Nigerian Court of Appeal, have found in his favour in very emphatic terms.
yes,
And if the Supreme Court were to do the same, the case for expecting the Nigerian authorities to abide by the judgment of the court might be overwhelming. But you're now saying, well, it's a legitimate factor that the Secretary of State should have borne in mind that his officials don't expect the Nigerian trial to be free and fair.
my lord, it's not should have, they have borne it in mind, and it's obviously continues to be relevant. And I don't accept that it's having my cake and eat it. I mean, obviously, when a court, even despite the enormous political pressure, finds in favour of an individual, that doesn't mean there hasn't been political pressure. It means that despite the political pressure, it has nonetheless found in favour of that individual. But obviously, that political pressure remains on these appeal proceedings. And that's the judgment that the respondent has set out in the evidence before this court. There's no other judgment.
Why does that mean that the Secretary of State was obliged to reach a concluded view on whether Mr. Kanu had been unlawfully treated?
Well, my Lord, because the Secretary of State's obligation to reach a concluded view is not dependent on other courts, her own internal concluded view. It's dependent on whether she is able to make that assessment based on the evidence. A part of the evidence is the judgments of the courts of a foreign country. That's evidence. But it's not the only evidence. And a judgment of a foreign country may find that there hasn't been an extraordinary rendition for all sorts of reasons. The Secretary of State, for example, in the Nazanin-Radcliffe case, would not rely on the conclusions of an Iranian court, because its judgment would have been that the Iranian court's conclusions were the result of political pressure and unreliable. But those conclusions would have been relevant evidence on some question or another. And so my argument in relation to the Secretary of State's requirement to reach a concluded or clear view and non-provisional view is that that is what is required as a matter of logic and also as a matter of legitimate expectation by Abbasi in the passages that we're going to look at. But it is also required because the evidence has now got to a stage where no other reasonable conclusion is possible. That's ground two. And so the court in Abbasi at 283, paragraph 92, summarizes the position. Clear acceptance by the government of a role in relation to protecting the rights of British citizens abroad where there is evidence of miscarriage or denial of justice. The words emphasized contain no more than a commitment to consider making representations which will be triggered by the belief that there is a breach of the international obligations. This seems to imply that such consideration will at least start from a formulated view as to whether there is such a breach and as to the gravity of the resulting denial of rights. And then the court goes on at paragraph 98 on the next page. These statements reflect the fact that, to use the words of Everett, it must be a normal expectation of every citizen that if subjected abroad to a violation of a fundamental right, and I say again, it's a necessary prerequisite that there is a judgment about whether that has happened, the British government will not simply wash their hands of the matter and abandon him to his fate. And then at paragraph 99, this is an important passage, paragraphs 99 to 100, and rather than read them out, could I ask you to read those passages?
Ms. Kilroy, just
Yes.
as a matter of the structure of this judgment, Lord Phillips said at the paragraph you showed us, 80, there are three considerations.
Yes.
And the first is the development of the law, which you've taken us to.
Yes.
The second is, was there a policy, which is paragraph 87, which I get. What's the third?
The third consideration is the normal expectation. This is what we're dealing with. The normal expectation of every citizen that if subjected abroad to a violation of a fundamental right, the British government will not simply wash their hands of them. I'm just trying to find where. Yes, you can see that from paragraph 95. We shall revert to the extent of any legitimate expectation in a case such as his,
Thank you.
after we have referred to the third consideration.
Just
my yes,
tidy
no,
mind.
I understand.
My tidy mind.
It took me a while to locate it as well.
Thank you very much.
So that's the third consideration, and then it's paragraphs 99 to 100.
Sorry, what's the third?
What's the?
The third consideration is,
Which weighs in favour of the possibility of judicial review.
Yeah.
That's at the end of paragraph 95. So the first consideration was the reviewability of prerogative powers.
yes,
The second consideration was the legitimate expectation engendered by policy statements. And the third consideration was an additional legitimate expectation, and that's the one at 98,
right.
read together with 95. So it's not rooted in policy statements, it's in the normal expectation of every citizen.
Yes,
And so you can see there that, that there is a balance between the request and the foreign policy considerations. And at 100, one vital factor, and that is one of the vital factor to be thrown into the balance, as the policy recognises, is the nature and extent of the injustice which he claims to have suffered. And then the court goes on to say, even where there has been a gross miscarriage of justice, there may perhaps be overriding reasons of foreign policy which may lead the Secretary of State to decline to intervene. However, unless and until he has formed some judgment as to the gravity of the miscarriage, it is impossible for that balance to be properly conducted. And in my respectful submission, when you look through all of those passages together, 92, 98, and 100, it is clear that the critical factor in performing that balance is making an assessment of whether there has been a gross miscarriage of justice, and if so, how grave it and its gravity. I mean, if it's gross, one assumes it is grave, but whether there has been a grave miscarriage of justice, and only then can you properly balance the miscarriage against the foreign policy considerations. In my respectful submission, a provisional view just does not qualify as a as a proper exercise of balancing. There may, as I accepted when asked by my lords, be an interim, a preliminary position that has to be taken while an investigation goes on. But the ordinary expectation must be that when the evidence permits it, a clear view is taken. And if a clear view is not taken, there must be a really good reason for it. And in my respectful submission, there isn't a really good reason here. There is no proper expectation that anything is going to change. And you can see, again, the reference to a need for assessment of and the importance of a decision as to whether fundamental rights have been violated at paragraph 104. Because in those paragraphs 104 and 105, the court suggests some types of cases where judicial review would lie, in other words, where a remedy would be granted. The extreme case where judicial review would lie in relation to diplomatic protection would be if the Foreign and Commonwealth Office were, contrary to its stated practice, to refuse even to consider whether to make diplomatic representations on behalf of a subject whose fundamental rights were being violated. So again, on behalf of a subject whose fundamental rights were being violated. In such unlikely circumstances, we consider that it would be appropriate for the court to make a mandatory order to the Foreign Secretary to give due consideration to the applicant's case. So a mandatory order might even be permitted, but at 105 other possibilities are also canvassed. Beyond this, we do not expect it's possible to make general propositions. In some cases, it might be reasonable to expect the Secretary of State to state the result of considering a request for assistance. In others, it might not. In some cases, he might be expected to give reasons for his decision. In others, he might not. In some cases, such reasons might be open to attack, and in others, they would not. And then at 106 is the summary of the court's conclusions. And Roman 1, not an answer to a claim to say it's the prerogative, it's the subject matter that is determinative. So again, the emphasis that there has to be a good reason. At 3, Foreign Office has discretion to protect British citizens. It's indicated in the ways explained what a British citizen may expect. The expectations are limited and the discretion is a wide one, but there's no reason why its decision or inaction should not be reviewable if it can be shown that the same were irrational or contrary to legitimate expectation. But the court cannot enter the forbidden areas, including decisions affecting foreign policy. And then at 4, it's highly likely that any decision of the Foreign Commonwealth Office as to whether to make representations on a diplomatic level will be intimately connected with decisions relating to this country's foreign policy, but an obligation to consider the position of a particular British citizen and consider the extent to which some action might be taken on his behalf would seem unlikely itself to impinge on any forbidden area. And the extent to which it may be possible to require more than that the Secretary of State give due consideration to a request for assistance will depend on the facts of the case. So, my lords, in my respectful submission, this is a case in which the challenges to an internal decision-making process, there are no foreign policy considerations identified in the Secretary of State's evidence as to why this court cannot review the internal decision-making process. The question as to what action to take on the basis of the concluded view, I accept it enters into the area of foreign policy considerations. But the question of whether the appellant as the appellant's brother has been the victim of an extraordinary rendition does not, in my respectful submission. And the court in Abassi makes clear that inherent in the expectation of a British citizen is a prior assessment when considering requests for assistance, is a prior assessment of whether there's been a miscarriage of justice and its gravity.
Can we
Yes.
Can we just go back to paragraph 100, which is obviously one of the most important, if not the
Yes.
most important. In this. What is meant by until and unless he has formed some judgment? What does some judgment mean?
Well, my lord, in my submission, it means a judgment as to the gravity of the miscarriage. And that is, it has to be a judgment which is commensurate to the question, or which is appropriate to the question that's being asked. And that's why I started off by looking at the ways in which a judgment about whether to intervene by requesting release or designating individuals for sanctions whether a judgment as to whether the miscarriage of justice had in fact taken place, the extraordinary rendition had in fact taken place, could make a difference. It could make a difference for the reasons that I set out. And in those circumstances, it's necessary to make a judgment about the gravity of the miscarriage of justice.
But you say some judgment must mean a final concluded judgment.
Well, in this context, I say that it does. I mean, I accept, as I did at the start, that first of all, in the early stages of a detention, there is an investigative process that has to be gone through. And that in those early stages, forming some judgment to decide as whether to intervene may be satisfied by the preliminary or the provisional view. But we are not in the preliminary stage anymore. We are 2 years on, and the evidence has emerged and is clear. And in my respectful submission, I mean, it may be that this is purely a point on rationality. The judgment that is made has to be a reasonable one. It has to be one that is capable of allowing the Secretary of State to reach a conclusion on the question that he is asking himself. In other words, what is the balance between the foreign policy considerations at play in deciding, for example, to announce that a foreign state has engaged in an extraordinary rendition? Those are the foreign policy considerations. I balance those against the miscarriage of justice. And if my view is provisional in that balance, then in my respectful submission, it's less likely that the balance is going to fall in favor of making a public statement, because the expectation is that the view may change. I mean,
suppose the view is, well, the Court of Appeal judgment looks pretty devastating to us, but they did grant a stay, and the matter is on appeal to the Supreme Court. And if the Supreme Court were, maybe unexpectedly, but we don't know, if they were to reverse the Court of Appeal and say that there's nothing wrong with this trial at all, then we, the government, or I, the Foreign Secretary, would have, might have to reconsider my view.
Yes. Well, my lord, at one point, the respondent suggested that what the appellant was asking for was a final view that could not be changed in the form of a sort of court judgment. That is not what the appellant is asking for. I accept that if some entirely unexpected fact came to light, for example, the Nigerian government was suddenly to produce a non-forged extradition warrant, that had been agreed with or obtained from the Kenyan government, that would be a reason for reconsidering a concluded or clear view. It's not the appellant's submission that the view is fixed forever, but what the appellant's submission is that the Secretary of State has got to conduct a balancing exercise between foreign policy considerations involved in escalating steps, which is what the appellant is asking for, escalated steps in circumstances where previous steps have not worked. And in order to conduct that balancing exercise properly, she has got to reach a clear view on the evidence in front of her, unless there is some good reason not to. And I've already showed you that the appeal is not on its face a good reason not to. The appeal does not suggest that anything further will come in terms of the findings of extraordinary rendition. And so in those circumstances, there's no good reason to wait for the appeal. And here I should emphasize that there is, of course, a distinction between what you do as a result of your view and the view. So I accept that one of the factors that the Secretary of State may take into account in deciding whether to state the view will be the possibility of change in the Supreme Court, or whether to ask for release. I accept that at that stage in the analysis, the appeal is relevant. Of course, it's not the appellant's case that that should change the position, but that's not the argument that I'm making here today. The argument I'm making here today is that the precursor for all of this proper due consideration that the court in Abbasi says must be carried out is reaching a non-provisional view in circumstances where a provisional view, I say, is no longer appropriate. It cannot conceivably be said to be appropriate. No one else has found it necessary to reach a provisional view, the courts, the United Nations. And of course, when a British citizen is subject to an ongoing serious violation of their rights, which puts them at risk in circumstances where they're being detained by someone who has already tried to kill them, the urgency of reaching a clear view is obvious in my submission. So another good reason why a provisional view maintained for over 2 years is simply not appropriate. There's no evidential basis for it. There's no rational basis for it. And it's inappropriate in circumstances where vexed decisions have to be made about how the respondent is going to properly deal with an ongoing serious human rights violation of one of its citizens. And in my submission, what the Court of Appeal in Abbasi makes clear is that an essential first stage and an essential part of the expectation is that that judgment will be reached.
Can I just,
yes.
That's your first ground of appeal, that the judge misinterpreted Abbasi or failed to understand Abbasi?
Yes.
That when Abbasi talked of a formulated view and some judgment in the context of legitimate expectation, it meant a final or firm judgment, conclusion, view. But if the judge didn't get it wrong, you're still saying, well, on the facts of this case, the decision was irrational.
Yes. Well, that's ground two. I mean, I should, in passing, I should deal with what the judge said is that this was a Thameside type exercise, and that's what Abbasi meant, is that it was simply an exercise of gathering information, asking the right question, and then gathering the right information to allow it to be answered. And in my respectful submission, that is obviously wrong. Conclusions do have to be drawn, and those conclusions can be challenged, as we saw from paragraph 106.3 to 5 of to 6 of Abbasi, which is because those conclusions can be challenged as irrational. So it's not simply an information gathering exercise. That's why the judge rejected the appellant's argument, and he was wrong to do so. There's simply nothing at all to support it, and it conflicts with the language of Abbasi. So,
speaking for myself, I think Abbasi is the important case.
Yes.
Although I can't remember when I sat on a public law appeal when fewer than 25 authorities were in the bundle. But actually, in this case, Abbasi, whatever it decides, was binding on Mr. Justice Swift. It's binding on us. I don't think it's suggested that it's been altered by anything subsequent. So Abbasi doesn't refer back to Thameside. You may be right that Mr. Justice Swift's reference to Thameside is wide of the mark, but I still think that the question, as it seems to me, is whether the Secretary of State has failed to comply with what you might call for short the Abbasi obligation.
yes. Well, my lord, I accept that, and I agree with it. I mean, some additional authorities have been added into this bundle, which was much smaller in the administrative court, because precisely the reason that you've given, partly to deal with the ground 3, which suggests that there's no duty of fairness in these types of cases. But my lord, yes, Abassi is the key authority, and I just on the question of formulated, final, concluded. I mean, final view. I've already said it's not the appellant's case that this has to be fixed. It's the appellant's case that a view has to be taken which is sufficient to allow the Secretary of State to properly consider the requests that are being made. I mean, that may be the better way of formulating it. And so that is why I started off with what difference could it make? What the appellant is now asking for is an escalated strategy. I make no bones about that. It's an escalated strategy of seeking, publicly requesting release, publicly stating that the appellant's brother, Mr. Kanu'S, has been subjected to extraordinary rendition, imposing sanctions. These are escalated steps. They go beyond simply raising concerns. Now, in order to properly consider those escalated requests, in my respectful submission, the respondent has got to address whether the conditions for those escalated requests are met. And in my respectful submission, that means that he has to address whether there has been a breach of the appellant's fundamental rights, not provisionally, but whether it has occurred, whether there has been an extraordinary rendition, because otherwise he's not complying with the appellant's, Mr. Kanu'S, legitimate expectation that his requests be given due consideration. Realistically, by maintaining a provisional stance, he is stymieing those requests before they get out of the starting post. Because realistically, no Secretary of State is going to call out a foreign government for having been involved in an extraordinary rendition where the Secretary of State has only reached a provisional view on that question, or call for his release.
But you accept, as you must, that Mazi says in paragraph 99, whether even to make representations is a matter entirely for the Secretary of State's discretion. Here, there have been plenty of representations. It's a fortiori whether the Secretary of State, the courts cannot possibly say the Secretary of State must go public. You accept that. I appreciate that.
Yes.
A matter of regret to your lay client and his brother, but we are bound by Mazi, and
Yes.
Mazi makes that very clear.
It's never been any part of the appellant's case to seek to obtain any kind of declaration or order in relation to what steps should be taken. This case is about the decision-making process that leads up to it. And it really, I mean, it's a pretty simple point in the end. Is the Secretary of State 2 years on entitled to continue to base her decisions as to what to do, including on the escalated steps, on a provisional view in circumstances where the evidential picture is about as clear as it could possibly be? That's ground 1.
It is, yes.
Can I come on to ground 2?
That's rationality.
Which is rationality.
I thought you'd already made submissions on that, because
It's certainly going to be short.
alternative. That an alternative mirror?
Yeah,
If you're right on your first thing, you put it either on the basis of expectation or on the basis of rationality.
well, I do, but rationality is logically a separate argument in the sense that it's even if he doesn't have a legitimate expectation that a concluded view be taken, it's irrational now based on the evidence.
Yeah, it's
To-
irrational now for the reasons that you.
But that I've already given, because the position is so clear.
Yeah.
And my lord, in terms of the judge's judgment below, the reasoning the judge gave, which is at paragraphs 31 to 32 in core bundle 113 to 114, he has conflated the decision to state the view publicly, and has said that it's rational for the Secretary of State to conclude that their view should not be stated, with the prior decision as to what the Secretary of State's view is. And that is something that the respondent himself did consistently until these proceedings, in all his pleadings and skeleton arguments, which is to suggest that the rationale for his decision not to reach a concluded view was that reaching and stating that view would be contrary to foreign policy considerations. But that is folding these two steps together, and you can see how the judge does it.
You say you're not seeking a public statement. You can't, and you don't.
Well, my lord, I don't want to go as far as say I can't. I'm just in this challenge. This challenge is
You're
about.
not.
I'm not.
Well, that's
Yes.
good enough for me. So
We
you're not seeking a public statement. So therefore, however the judge dealt with it, you maintain the rationality challenge before us, effectively on the same basis that you've just outlined.
yes.
So there's nothing new.
There's nothing new except to say that the judge got it wrong when he rejected
Yeah.
our argument on the basis that, and you'll see this at paragraph
So
32.
rather like my Lord's intervention in relation to
Yes.
ground one and Tameside, speaking for myself, I don't think that will ultimately matter. What will matter will be ground two and whether or not you're right about the rationality challenge.
I'm happy to proceed on the basis that I'm simply advancing the arguments without.
You've made the
looking-
point that the judge was wrong because he conflated the 2 points.
He conflated it, and as a result, he found that there were foreign policy reasons as to why the Secretary of State was maintaining his view, was refusing to state the view. And of course, my submission, and you'll see this in the skeleton argument, is that there are no foreign policy reasons. So the Secretary of State hasn't identified any foreign policy reasons in his evidence. Ms. Broughton gives none for maintaining the provisional view internally. What is identified, of course, is foreign policy reasons for not stating the view publicly. I absolutely accept that foreign policy reasons have been given for that in the various submissions and so on. But all that has been said about the internal view is that the evidence is evolving. And your lordships have my submission that that is an irrational position now. So that is ground two. But I should also say before I leave ground two that there is a judgment in the bundle in which the courts did intervene in not dissimilar, not exactly the same, but not dissimilar circumstances, which is the CAT case, tab 17 of the bundle. And in that was a case in which the Secretary of State was being asked to, or had to make a decision about whether to sell arms to the coalition, in particular Saudi Arabia. You can see this is it's tab 17, page 535 of the authorities bundle. And one of the criteria that the Secretary of State had to address was whether there was a risk that those arms might be used in commissions of violations of international humanitarian law. And what you can see at paragraphs 61 to 63 is a very similar sort of argument being made by Cat, which is that the Secretary of State had refused in that case to reach any conclusion about whether the coalition of which Saudi Arabia was a part had been involved in past violations of international humanitarian law when deciding whether there was a risk that it would commit future violations. So you can see the argument at 61 to 63, and then again at 138 to 139.
Before we plunge into this long and complicated case in which I know Sir James is Secretary of State, would tell us what help does it give us other than what we find in Abbasi?
Well, my lords, on this question of rationality, it simply shows that the court in that case, and you'll see this from paragraphs 138 to 139 and 145 of the judgment, accepted that given the wealth of information and evidence that was available on whether past violations had been committed, and given the relevance of that to assessing future risk that violations would be committed in the future, it was irrational not to make that assessment. And in particular, the court took into account that other important and authoritative bodies, including Human Rights Watch and other such bodies, had reached, they had been able to reach those conclusions themselves. And in my submission, the same sort of reasoning applies here. And I really rely on it just to show that the court expressed some trepidation about reaching a conclusion of irrationality in circumstances where the respondent had said, in that case, the International Trade Secretary, had said that there were extensive foreign policy considerations involved in reaching those decisions, but it nonetheless found it was irrational not to do so. And it's just an example of where the court saying you cannot assess this question that is before you properly without making these kinds of judgments. And I say this process applies here. Can I turn now to ground 3?
Yes.
Fairness.
Yes.
And my lord, this is important for me in terms of looking at what the judge actually said, because the judge concluded that the respondent, when deciding whether to provide assistance to Mr. Kanu, is not exercising a power that attracts an obligation to act fairly. And that conclusion just simply cannot be sustained in the light of the GCHQ case, which says in terms that prerogative powers are reviewable on the basis of fairness and rationality.
Mm-hmm.
my lord, just it's paragraph 35 of the judgment at 114 where he reaches that conclusion. And because I should give you the references in the GCHQ case that the respondent has now accepted that that is right in his skeleton argument. It's Lord Diplock for tab 2, 410C to 411H, the authorities bundle at 102 to 103.
Hold on a moment, Ms. Gilroy, just so
Yes.
I can understand.
Oh, yes,
The first ground is legitimate expectation.
yes,
Second ground is rationality.
yes.
If those will either succeed or fail. If you succeed on one or other of those, you don't need this. Is that right?
Well,
And if you fail on 1 and 2, does this save you?
well, this is a distinct ground in this sense.
I appreciate it's a distinct ground
yes.
of appeal. I'm just looking at the overall.
How does it
fit in?
So even if we were to lose on grounds 1 and 2, this ground would still have traction. Let me put it like that. Because it is the appellant's case that the respondent has an obligation in fairness to either tell him what the provisional view is, or at least to identify the factors which might cause that view to become a concluded view, cease being provisional, so that the appellant can attempt to shift the view from provisional to clear or firm or concluded. So that is the appellant's case. So it survives.
So it survives because this is premised on the basis that provisional view is okay.
Yes.
I get that. I understand.
It is. So I agree, it's not necessary it still might be necessary even if we succeed on grounds 1 and 2, because there will be a process that the Secretary of State has to go through in order to reach, it's ground 1 really, not ground 2. If I succeed on ground 2, that it's irrational to maintain a provisional view, that will be the end of it. If I succeed on ground 1 but not ground 2, then there will still be a process that needs to be gone through by the Secretary of State in deciding whether to reach a concluded view or not.
And if you lose on both, you say this is still relevant because it goes to the information effectively to be provided, you say, in relation to what then would be the still legitimate provisional view.
Yes.
Can I understand that?
Because on any view, a provisional view presumably comes with it the possibility of change.
Yeah.
And the question is, how can the appellant, in circumstances where the respondent has repeatedly said he's not an investigative body, assist him in achieving that change?
You'll forgive the questions. It's just
No.
My experience. It's very good to see where these things fit in, and rather than this being a sort of standalone attack on some part of the judge's reasoning, it actually, I fully understand that, has a purpose.
Yes, well, I'm very grateful. It's something I should have identified myself.
That's right.
My lord, the judge was wrong because it's inconsistent with GCHQ.
And you were giving us.
I was giving you the paragraph numbers 410C to 411H, authorities 102 to 3, authority page 102 to 3. This is tab 2 of the bundle. And you can see there the reasoning which is of the majority, the common law powers, prerogative powers are amenable. This is at C onwards of page 410 to review, subject only to C subject matters of subject matter. And my lord, without asking you to read it all now, but those, if you then, your lordship's turned over the page, you'll see it 411 F to H. As respects procedural propriety, I see no reason why it should not be a ground for judicial review of a decision made under the powers of which the ultimate source is the prerogative.
I just don't see how this applies to the present facts. I really don't.
Well, my lord, it's simply that the court has found that as a matter of principle, there is no obligation to act fairly because of this type of decision that is being taken. That's what the court said. And in my respectful submission, that is wrong.
All right. Well, if it's wrong, what's right?
So-
Anybody in public life taking any decision which affects anybody must do what? Complete the sentence.
Well, my lord, I accept it must act fairly is the answer. That's
Yeah.
complete. Now, what fairness requires?
You're
of
talking
course-
about procedural fairness.
Yes, procedural fairness.
Well, what does procedural fairness require? And Sir James asserts in his skeleton paragraph 40, he may be right or wrong, that the Secretary of State has regularly provided the appellant with updates and steps taken, as well as why the Secretary of State has chosen not to pursue a certain course in Mr.
Yes.
Kanu'S case. And what more did the obligation of procedural fairness require?
This again relate, all of these grounds of challenge relate to the provisional view. So the issue is that the Secretary of State has reached a provisional view. We don't know what it is. And so it's therefore not possible to challenge the view if it were irrational or otherwise mistaken. And we also don't know why the view has remained provisional. Why is the view provisional in the face of all of these developments? The only explanation that has been given is evolving evidence, but as I've already explained, that does not stack up. We don't know, for example, whether the Secretary of State has sources that have told him that something is going to happen in these proceedings that will affect the evidential picture. We don't know that. We think not, because it's so clear, and that's my submission. But if the Secretary of State is being misled, for example, or has misunderstood, is mistaken on the position in circumstances that, whereas I've said she has said she doesn't have an investigative role, then the appellant could correct those mistakes. But we don't know, we don't have any of this information. And on ordinary principles of procedural fairness, a decision of this kind, which, as I've said, has the capacity to influence what steps are taken on sanctions, on public statements, on private representations to the Nigerian government, on those escalated steps. In any ordinary situation, we would be entitled to know what the reasons were for the provisional.
Yeah, I'm afraid that's a very broad brush assertion. It doesn't seem to me to derive from the case law.
Well, my lords, maybe we should look at duty then very quickly to see what it says. So it's tab 4. It's page 560. so page 156 in the bundle,
Yes.
and it's paragraph D.
D to
onwards.
G, it's a
D
very
to G.
famous passage.
It's very famous, and really, this relates to an act of Parliament. But in my submission, as I've said, it applies equally, and GCHQ makes clear to prerogative powers. There's no reason why the same. I mean, it's a common law right or duty to act fairly.
Yes.
So the standards of fairness are, so I'm going to skip over one on the basis that it's clear that it applies in relation to prerogative powers in exactly the same way as it does in statute. The standards of fairness are not immutable. They may change with the passage of time, both in the general and in their application to decisions of a particular type. I accept that. The principles of fairness not to be applied by rote identically. What fairness demands is dependent on the context of the decision, and this is to be taken into account in all its aspects. 4, an essential feature of the context is the statute. That doesn't apply here. 5, fairness will very often require that a person who may be adversely affected by the decision, in this case, to maintain a provisional view, will have an opportunity to make representations on his own behalf, either before the decision is taken or with a view to producing a favourable result, a concluded view, or after it's taken with a view to procuring its modification, or both. And the after it's taken usually leads to reasons being given. At 6, since the person affected usually cannot make worthwhile representations without knowing what factors may weigh against his interests, in other words, here we say why the provisional view is being maintained, fairness will very often require that he's informed of the gist of the case, which he has to answer. And then the explanation as to why that is so is given at 563, and this is in relation to someone who is facing a longer prison sentence. And I say, obviously, in this context, the gravity of the situation is at least as serious. It's at least as grave. You see at 563G, the court addresses whether an explicit disclosure of the substance of the matters on which the decision maker intends to proceed must be disclosed. Whether such a duty exists, how far it goes, and how it should be performed depends so entirely on the circumstances of the individual case that I prefer not to reason from any general proposition on the subject. Rather, I would simply ask whether a life prisoner whose future depends vitally on the decision of the Home Secretary as to the penal element, and here we say, for the reasons I've explained, as to whether a view is taken on his extraordinary rendition, and who has a right to make representations upon it, and no one has suggested that the appellant is not able to make representations on what should happen, should know what factors the Home Secretary will take into account. In my view, he does possess this right, but without it, there is a risk that some supposed fact which he could controvert, some opinion which he could challenge, some policy which he could argue against might wrongly go unanswered. And so in my respectful submission here, what all the appellant is asking is to know, well, first of all, what the provisional view is, but if there are, and there haven't yet been, identified reasons why he cannot be told, for example, on the grounds that he might not keep it secret, that it might be come to the attention of the Nigerian government and therefore engage all the foreign policy considerations of a public statement. If that position were taken, and there's no evidence to that effect, but if it were, at the very least, he ought to be told what factors have caused the respondent to maintain a provisional view, so that he can, 2 years after his first detention, persuade the Secretary of State to reach a concluded view. That's what he's asking for, because the basis on which the provisional view has been taken may be erroneous. And my lord, I was going to, I'm conscious of the time, just give you some passages just in terms of one of the points that's made by the Secretary of State in his skeleton argument is, yes, the right of fairness does arise in prerogative cases, but there still needs to be some reason why there is a duty of fairness in an individual situation. So that doesn't go to the context of what fairness requires, but whether fairness arises at all. It's still the Secretary of State's position that the duty to act fairly, whatever that may require, doesn't arise at all. There is no duty to act fairly, says the Secretary of State. And in my submission, the Secretary of State's submitted position on this, like the judges, is wrong. There doesn't need to be.
You may be right. You may be right about that. That if one talks about the duty of procedural fairness, which rather than the substance of the result,
Yes.
then you say that there has been at every stage really a duty on Secretary of State to explain why he or she is taking or is not taking a particular step.
Yes, so far as possible. Now, I accept that there may, in some circumstances, be foreign policy considerations that may come into play. But what the court has made clear in GCHQ is that you can't just assert foreign policy considerations. You have to provide evidence as to why those considerations preclude you from doing what would otherwise be required as a matter of fairness. That's what the court found in GCHQ. And there's been no such evidence here. There's been no explanation as to why no evidence as to why the appellant cannot be told what factors have, despite all these developments, persuaded the Secretary of State to maintain a provisional view. What it is that he thinks is going to happen. And my Lord, there are a couple of authorities that I just wanted to give you references in, which I might as well do if you're willing to sit. So Yusuf in the Court of Appeal, tab 12, authorities 388, page 388 at page 402. Lord Justice Laws at paragraphs 23 to 24.
Yes.
A judicial review of prerogative power must found entirely on standards which are the product of the common law. Of these, reason and fairness are the cornerstones. So it's really just to emphasize that the duty of fairness comes from the common law, and this is a common law power. You don't need anything else to impose a duty of fairness. It's the Secretary of State that has to show why the duty of fairness does not apply in this context. It's not the appellant who has to prove or find some basis for a duty of fairness to arise. And indeed, as this is not in the authorities bundle, but it's so well known, it's not necessary for it to be in my submission, which is in Board of Education and Rice, and this is the point I think my Lord made. Lord Lawburn famously said, listening fairly to both sides is a duty lying upon anyone who decides anything.
Well, yes.
But of course, it applies with special rigour, that duty, to decisions with grave consequences. And there is a case in the bundle about the prerogative of mercy. Again, this is all to do with people whose lives and liberties are at stake. This is Lewis and Attorney General Privy Council case 2001 2 AC 50. It's tab 7, authorities 211. And the relevant passages are 76B to F and 78E to F, just emphasising that the duty to act fairly is even more acute in cases where people's fundamental rights and right to life are engaged, as in my submission they are here. So for all those reasons, my Lord, it's my submission the judge got it wrong. The Secretary of State got it wrong. Neither of them considered the question my Lord asked me, which is, what does fairness require in this case? They didn't, because they assumed that they didn't need, that the Secretary of State did not need to act fairly. And so for that reason alone, the appeal should be allowed. The Secretary of State must now ask herself what is required as a matter of and why the appellant cannot be told, be given the information that he seeks.
Thank you very much, Ms. Kilroy. You've been most helpful. 2:05, Sir James.